Hello, and welcome to Constitution Pit Stop. Today, we will be talking about the Interstate Commerce Clause, which has been cited as a major source of congressional power as well as, in the opinion of some, a catalyst for federal government overreach. But before we get there, let's start with the basics. The Commerce Clause is located in Article 1, Section 8 of the U.S. Constitution, the article and section where legislative powers are enumerated. It reads that, quote, "The Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes," unquote. The Interstate Commerce Clause regards the power to regulate among the several states, and that is what we will be focusing on today. Remember, inter means between, so this clause is regarding the power of Congress to regulate commerce between states. And as the courts have shown, commerce can be money, goods, or business. Now let's look at why the Commerce Clause came to be, the founders' intentions. Like many powers granted to Congress, the necessity of the Commerce Clause stems from the lack of a strong central government under the Articles of Confederation, which were the original government of the United States. The lack of a strong central government under the Articles resulted in an economic depression. The Commerce Clause was part of the solution. But as we know, the Interstate Commerce Clause itself can't be fully understood until we look at how it is used by the federal government, and we can observe this through court precedent over time. First, let's look at Gibbons v. Ogden, 1824. This case is about steamboats, water, and two seriously upset men. Gibbons had a license from the federal government to exclusively operate steamboats in waters between New York and New Jersey, whereas Ogden had one from the state of New York. This begged the constitutional question: does the New York license stand, or does it interfere with the right of Congress to regulate interstate commerce? It was ruled that Congress has the power to regulate interstate commerce, including navigation. Thus, because the federal law is supreme law of the land, and there was a violation of the Interstate Commerce Clause, the New York license was struck down. So, this case serves as a baseline, establishing the use of the Commerce Clause as a power to the legislature to impose their supremacy when interstate commerce is involved. But since 1824, the use of the Commerce Clause has evolved and expanded. A prime example comes from over a century later, during the Civil Rights era. In short, Title II of the Civil Rights Act of 1964 ensured that places of public accommodation, such as parks and restaurants, could not discriminate or refuse service to customers on the basis of race. And so, we get the case Heart of Atlanta Motel, Inc. v. United States. This motel refused service to black customers, and argued that the imposition of Title II to their private motel was government overreach and outside the bounds of their constitutional power. However, the Supreme Court ruled in favor of the U.S. The court opinion emphasized that because the motel got much business from outside the state, interstate commerce was affected, and therefore the federal law of the Civil Rights Act could be applied to this motel. After this ruling, the same mentality was used to apply the Civil Rights Act in private businesses that somehow had an effect on interstate commerce throughout the nation. Here, we see an expansion of how the clause was used from Gibbons v. Ogden, and Heart of Atlanta Motel also gives an example as to how the clause was used to impose law for justice across the United States. However, many argued that the Interstate Commerce Clause has been a catalyst for federal government overreach. The Constitution dictates specific powers to the federal government, and uses the 10th Amendment to ensure that powers not enumerated to the federal government are reserved to the states. Many people believe that the use of the Commerce Clause has been stretched by the federal government, and has allowed them to impose in a way which tapers with the delicate balance of power between the state and federal governments. To address this, let's look at Wickard v. Filburn, 1942. At this time, there was a federal law in place restricting the amount of wheat that could be harvested by a farmer. Filburn, the farmer, harvested close to 12 acres above what was allowed for him under the law, but argued that because the wheat was for his own personal use and not for sale, it would not affect interstate commerce and thus could not be regulated. However, the Supreme Court upheld the law that limited how much wheat farmers could harvest through the Interstate Commerce Clause. In short, their reasoning centered around how even though one farmer, like Filburn, exceeding this restriction for personal use might have a negligible effect on interstate commerce, if many farmers do this, it will have a considerable effect on interstate commerce because the farmers will be using their own wheat rather than buying it from others. Thus, the aggregate activity would have an effect on interstate prices of wheat. So, even though no state lines were physically crossed and no effect was physically measured, the court used the Interstate Commerce Clause to uphold a law restricting the wheat harvesting of farmers. Alas, although we see this controversial and expanded use of the Commerce Clause, there is a more recent and important example of the limitation of the Commerce Clause. U.S. v. Lopez, 1995, was a landmark case for this. It was found that the federal 1990 Gun-Free School Zones Act was not a law that, even in aggregate, would have a significant effect on interstate commerce. Thus, the act was found unconstitutional because it surpasses the power of Congress to create law under the Commerce Clause. While after Wickard v. Filburn, the powers of the legislature through the Commerce Clause seemed almost indefinite, this case clarified that ruling, emphasizing the need for present economic activity that would have a sufficient effect on interstate commerce to justify federal regulation. So, over time, we have seen the power to the legislature through the Interstate Commerce Clause ebb and flow. What is important to take away from this is that when an activity has a substantial effect on interstate commerce or aspects of business between states, the federal government has the power to regulate that activity. Today, the Commerce Clause remains pertinent in many U.S. issues. Take state marijuana regulation despite federal criminalization. In order to fully understand the law regarding this issue and many others, it is essential to understand the Interstate Commerce Clause and how it is used. But that's all we have on the Interstate Commerce Clause for today. Thank you, and I hope that you learned something new about the United States Constitution.